Hello, would you like to know more about the new public charge rule? Well, this video is for you. My name is Jorge Molina. I am an immigration attorney based in Dallas-Fort Worth and serving clients worldwide. And today we're going to talk about the new public charge rule. So on December 23rd, 2022, immigration started processing adjustment status applications in a new version. The reason for that is that the new public charge rules came into effect. Now, this is not like the public charge rule that was announced back in 2020 that created a lot of disruption. There was a lot of lawsuits. As a matter of fact, this new rule actually codifies a memorandum that was published in the 1990s. And indeed, it's somewhat welcome by us because it adds clarity to the process of determining whether someone is a public charge. And the reason we need to do that is that under the immigration laws of the US, if someone is going to become a charge to the government or to the people of the United States, they're not allowed into the country. So we've had these laws or regulations since the 1800s. This is one of the first laws passed regarding immigration. So back in the 1800s, they wouldn't allow people that were considered paupers or people who just come to beg to the United States. So this is the origin of this. This is not really something new. It's been in the books for centuries, literally. But in the 1990s, they changed how we process these and we created new regulations. We haven't had substantive changes until now. So for about 20, 25 years, we've been operating under a memorandum issued by immigration in 1996. So what does the public charge rule do, the new regulations? So it defines who is a public charge. And the definition of someone who is a public charge is someone who's likely to be primarily dependent on the government for subsistence. Okay, and they further define that as individuals who have received government assistance in the form of cash assistance or being institutionalized in either a hospital or any other facility at government expense. So we have now a clear picture of who would fall within the public charge categories and why they would be denied. And we also know now, thanks to the regulations, what are the factors that immigration officers will consider to determine someone is going to be a public charge. So there's three sets of factors to consider. First is whether someone submitted an affidavit of support and whether they were required. In most instances, if you submitted an affidavit of support and you did not receive a public benefit, you would be deemed not a public charge. In other context, if you did receive a public benefit, the immigration officer or immigration judge would consider that person's age, health, family status, assets, resources, financial status, education, and skills. So in determining whether someone's going to be a public charge or if they're going to deny someone for this reason, they need to ascertain all these factors. So whether someone applied for public benefits before, whether they have an affidavit of support, and these additional factors that I'm telling you. So in most circumstances, if you haven't applied for a public benefit in the past and you have an affidavit of support, it would be approved. But if you have applied for a public benefit in the past and you have an affidavit of support, they would likely consider the additional factors. Also, immigration made very clear that should they need to deny a case, they would provide a full assessment as to their reasons. So it's not really a discretionary matter that, any officer, because, they thought that a person would be a good fit, could deny it for this reason. This is a significant difference from the rule from 2020. Now, if they will be denied for this reason, they must state it and go through the entire analysis, taking all these factors into consideration. Another welcome part of this rule is that it very clearly states that for someone to be considered public charge, they must have received or are likely to receive the public benefit, not their family members. So this means that if someone would apply for cash or would be eligible for cash assistance within the household, even if someone's applying for immigration benefits, that family members or household members application for that benefit does not hurt the person applying for an immigration benefit. And finally, the other next clarification is that immigration said that this rule only applies for people who want to be lawful permanent residents of the United States, not people in lawful status that is not permanent in the United States, also known as non-immigrants. If you have any questions about this, or you have a situation where you might think you might be subject to a public charge rule, consult a qualified immigration attorney. And if you like these videos, hit like, share, maybe subscribe to our channel. And we always welcome your comments. Again, I'm Jorge Molina. Thank you for watching.